Good afternoon, everybody. My name is Chris Justice. I'm a senior associate with Samfiru Tumarkin, and I'm here today to hopefully answer, as usually, as many questions as I can, all things employment law related. So whether it's something to do with a contract you've got a question about, something you're going through in the workplace, perhaps that you're wondering what your rights are with respect to, or maybe you've been let go, you've been offered a package and you're wondering whether or not the package is sufficient. Again, whatever it may be, definitely get your questions in, and I will do my best to answer as many as I can. And actually, speaking about terminations, people being given packages, there's some news going around that with respect to a number of companies, a number of people are losing their jobs to AI, to artificial intelligence. A lot of businesses are implementing the use of AI to further streamline the operation of the business. And as a result, a number of individuals are being notified that due to some corporate restructuring or reorganization, perhaps on account of AI or otherwise, that they're losing their jobs. And as far as I'm aware, some of the more recent news has managers and those in a managerial capacity losing jobs as a result of AI being implemented and these restructurings occurring. So on that topic, I wanted to definitely say that regardless of who you are, whether it's someone who's lost their job due to restructuring or AI or anything at all, you definitely want to give us a shout before you sign any release, before you sign any papers that the company wants to sign. In fact, I just got off the phone with a potential client who had been let go and was offered a severance package. But before her and I had a chance to speak, she had actually signed the full and final release and gave it back to the company because the company told her that if she didn't sign the release within a certain time frame, that they were going to pay her nothing or very little severance. And so worried that she was going to get nothing or very little and not wanting to ruin the possibility of getting something, she went ahead and signed the full and final release with respect to the severance package she got. So when I was speaking to her, I told her that now I'm not really able to step in and help because of the fact that you signed this paper. She signed the paper and essentially received 6 months of severance as a result of signing it. But I had told her that if she had not signed that same paper and it actually had contacted me, regardless of whatever deadline the company had put on her to sign back those papers, that she could have had an argument to be made that she was owed not just 6 months, but triple that, 18, maybe even up to 20 months. And so unfortunately for this individual, because she signed it, even though she did get some money as a result, she ended up leaving tens of thousands of dollars, if not more, on the table that she could have had she held off from signing it, even despite the pressure that was being applied to her by her former employer. And that's something that's very common, actually, is you'll be let go and you'll be under some pressure to get that back. You'll think that if I don't get this back to them within a week, I'm not going to get anything, or I'm going to get just my bare minimum entitlements. But people need to understand not to bother paying attention to those deadlines. Your rights to severance, they do not expire or get extinguished just because you missed a 7-day deadline that was put forward by your former employer. In fact, most of the time you have upwards of 2 years to go after a company in court if you want to go after them for more severance. So don't fixate too much on the deadline that's being placed on you to sign back that release. Give us a call first, and you'll quickly find out that those deadlines are just something that are artificial. They're just imposed on you by the employer because the employer does want you to sign the release. But unless you know what your full rights and entitlements are, you don't even know if what you're signing is giving you a third of your full entitlements, half, or even less than that. So definitely give us a shout before doing any of that, because as I say, in this woman's case, I wasn't able to help her by virtue of her signing the release, and there was a potential huge loss there that was suffered unbeknownst to her at the time. I had another individual actually call me not too long ago asking about a record of employment. So she was concerned that she hadn't been given a record of employment after she had been let go, and that this was going to cause a problem for her with respect to collecting EI benefits. And I spoke to her. I let her know that she was right as far as the record of employment having to be issued in a certain period of time. And if not, employers can potentially be in hot water as far as having to pay some extra money or even potentially getting fined by the government for failing to issue the record of employment. But after I started speaking with this woman more and more, I realized that her situation was more than just about a record of employment. She didn't know it at the time. She had been there for 6 years and they gave her 6 weeks of severance. And she thought that it was compliant with the law, that it was a fair package, a week for every year of severance that she worked. However, when I spoke to her, I told her that as a 6-year employee, you could actually get 6, 7, 8, 9, 10 months of severance. So that was another thing that I had to highlight for her, and something that a lot of people are, or at least have a misconception about, is they think, if you've been let go, you're owed a week, maybe 2 weeks per year of service. And as long as the employer provides you with that therefore that's a fair package. It's not really an issue, because she didn't bring that up at all. It only came as a result of my further questions and inquiry. And as I say, I explained to her that actually 6 weeks for a 6-year employee is extremely low. And that's when she realized that not only does she have a case based on the issue she was having with the record of employment, but actually a case to go after the employer for probably another 6 months of severance on top of the severance that she was offered. So a lot of times people do, in my experience, tend to fixate on very specific things. Maybe it's overtime, maybe it's vacation, maybe it's a record of employment, but severance is a huge thing all the time. And it's just sort of a mental note for those out there to make sure that you consider everything before you sign anything in terms of releasing a company from any claims you may have. And it just goes further to show that the amount of severance people can get oftentimes works out to 4, 5, or 6 weeks per year of service, not just 1 or 2, with the capability of getting upwards of 2 years of severance, depending on who you are and how long you've been at the company. With that said, before I touch on some other topics off the top, I'll get into some of the questions, because I do have some questions in here. So I'll start with Sir on YouTube's question, who's saying that they didn't sign an employment contract and the employee manual says that they cannot involuntarily resign. And they're wondering if this is enforceable. So a lot of times people don't actually sign a contract of any kind, an employment agreement, but then they're told maybe later on that there's a company manual or employee manual that has a bunch of language in there. And maybe it says, how much severance you would be owed if you're let go, or speaks to, in what situations you can resign or not resign. And a lot of times companies say, look, you maybe not have signed anything with our company, but you have to adhere to this employee manual, this company manual that applies to all employees across the board. But if you haven't actually signed that manual and you didn't get any benefit by virtue of signing anything along those lines, then just by pointing out the fact that there's an employee manual with some language in it is not going to typically be enforceable. It's not something that companies can generally rely upon to limit your rights or waive your rights in some respect. That usually requires you to actually sign a contract, like I say, some sort of employment agreement of some kind. So if you're being told that your employment is governed by a manual that you didn't even sign or agree to, but was just given to you, there's a high likelihood that the employer will not be able to rely upon it, whether it be to limit your rights or change your employment in some way or fashion. So if you're in a situation like that, you definitely want to give us a call, because it does happen quite a lot where individuals are told that there are certain terms of their employment that they have with the company, but they never actually agreed to those terms, or they never signed anything based on those terms. And that can be a huge difference maker when you're facing an employer who's saying quite the opposite. But thanks for the question, sir. I've got another one in from L on YouTube, who's saying that their employer is planning to reduce their commission structure. They're in sales and they've worked there for 23 years and they've been given 15 months of notice. And they're saying that another colleague of theirs in the same role has been given 18 months notice, but only has been with the company for 19 years. And the question is, do I have the legal rights to demand more, such as asking for 23 months? So it's a good question. I'm not quite sure why your other colleague who's worked less and has the same role got more notice. That seems a bit strange to me. I would think that if everything is equal, you should typically be given the same amount of notice. So I'm not quite sure why they did that, but there are a couple ways that you can go about this. Normally, when people are told that their commission structures are changing, or any term of their employment for that matter is changing in a significant way, a lot of times they're not given any notice whatsoever. And they're forced to have to make a decision almost on the spot as to whether or not they agree to these new terms or not. And in those cases where they're not given any notice, that can actually constitute what's called a constructive dismissal and entitle that employee to the same amount of severance that they would have got had they just been let go. Just by virtue of being told that a term of their employment is going to change significantly and no notice being given. And so that's one problem on its own is sometimes you get no notice and there could be a case for you to get severance. There are other situations where a company will make a big change to your employment, could be your pay, could be your duties, or maybe where you're located, but instead they give you a greater amount of notice. And the reason why the courts like when notice is given is because it allows the employee time to decide whether or not they want to agree to these changes or not. So by giving somebody notice, especially when it comes to a big change in your employment, you can hopefully use that time, or at least the idea is that you would use that time to decide, do I want to accept this or not? And if I don't want to accept it, and I know that my employment is going to change drastically, let's say 15 months from now, the idea is that the courts would then expect you to use that 15 months under the same commission structure you've got to try and look for another work, if that's something you're not agreeable to. When people are given notice about changes that are happening, it also depends on how long they've been there, their position, what age they are. That's going to generally determine how much notice they should be given. So for instance, if I have been with a company for 10 years, and I'm 35 years old and I'm a lawyer, and I have a colleague who's also a lawyer, who's been with the company for maybe 8 or 9 years, so maybe less than me, but they're 67 years old. In some situations, even though the 67-year-old might have had lower amount of service with the company than I did, it could be more appropriate to give that person more notice because of their age. So you got to think of it in more of a totality, in the sense of, what's the person's age? How long have they been at the company? What position do they have with the company? And how much money are they making in that position? And what's the availability of similar employment out there? So that could potentially explain why your colleague who had less years of service was given more notice. But I would still say, from a general standpoint, if you've been at a company for 23 years and you've been notified of a big change to your commission, if all the company's going to do is give you notice, then I would say, just based on the information you've given me, that you should get more notice. Frankly, 23 years in might depend on your age, but you should be looking at something generally between 18 to 22 months of notice. 24 months of notice, by the way, would be the most anyone can get. So I wouldn't necessarily expect to get that much notice. But it does seem to me like the amount of notice they've given you is a bit light. And if I were in that position, I would push, at the very least, for more notice, just to buy me some more time to decide whether I want to take on this new change in the structure, or, as I said before, utilize that time instead to look for a job that has a commission structure similar to the one that's already in place right now. So, Elle, without a bit of further information, I don't exactly, again, know why they offered different amounts of notice, but perhaps the ages of the two of you could factor in, or perhaps the money that you were making in both of those sales roles could factor in. It really does come down to a case-by-case basis, but I would still push for more notice if I were in that situation, at the very least. And I would start on the high end, because I know typically employers are going to push back and say, no, we're not agreeable to that. Can you do better? So I would probably start at something like 23, 24 months, but if I could land at something around 18 to 22, that would be at least more reasonable. I've got another question in from Art on YouTube, who's saying that they're a seasonal employee. They work all year round, and they have been told to sign a new contract, or essentially, I guess they have Art sign a new contract twice a year with no significant difference in the job. And the question is whether they can do this and if it's enforceable. So companies can have you sign, frankly, as many contracts as they want. Now, at the end of the day, if somebody signs 7 different contracts in a 3-4 year time frame and they're ever let go, they're likely going to be still viewed as an employee with 7, 8, 9 years, however many, of indefinite employment. So you can sign contracts with fixed terms, but the more contracts with fixed terms you sign, the more years that pass, you're just going to be viewed as someone who is an indefinite hire. You're going to grow to expect having to sign a new contract. And so the expectation is you're just going to keep working and keep working and keep working. Sometimes the issue comes when you look at the actual contract and you look at what's in that contract. Sometimes it'll say that the contract is for a 6-month period. And if they ever let you go before the contract is over, they only have to give you a week or 2 of severance. That's when employers can start to get into some hot water when they try to say that, someone should get less severance rather, because of the fact that they signed all these fixed term contracts each and every year. Like I said before, if that happens often enough, you're just going to be viewed as an indefinite hire, and you're going to get severance if you're ever let go based on all your years of service, not just for the most recent 6-month term or year-long term that you had. Especially if there's no significant difference in the job. It just seems like they're wanting to tie you to specific terms so that they can let you go without giving you as much. So I would be cautious about that. I would say as well, in general, I say this all the time, if you're an employee and you're being asked to sign contracts after you've already been working there for a number of years, the question still remains, why is it that they want you to sign the contract? What benefit are you getting by signing this? Or is it just simply a matter of them giving you some contract to sign that's got a bunch of terms in it that are only beneficial to the company? And I always look at those things with a bit of a raised eyebrow. And I would actually suggest, Art, if you can, to give us a shout and sort of give us an overview through a consultation that we can set up, but give us an overview of all these contracts that you've been signing, how long this has been going on, and have us look at the specific contracts to see if you are signing something that might be detrimental or not. And then we can better advise you on what impact, if any, there is of you signing the contracts. But in general, they can have you sign it and they can be enforceable. It just depends on exactly what is in the contract and what the specific circumstances are. But thanks, Art, for your question. I've got another one in from Lynn, who's on YouTube, saying, what happens if your employer forces you to sign a release before allowing you to leave the premises? Number one, I wouldn't sign the release. Especially if there's a question in your mind as to whether or not this package is good enough, is a fair package. Because what's the alternative? If you don't sign the release, what's the employer going to do? Are they going to say, okay, well, if you're not going to sign the release, we're just going to give you this amount of money, but you're not going to get this amount over here? Because if so, my guess is that even combining those 2 amounts is still going to be way much less than what you are potentially entitled to. So a lot of times people come to me and say, Chris, I need to sign this release. I'm being given 7 days. Otherwise, I'm going to lose money. And I quickly tell them, well, I would turn down that offer anyways. Let's say they're offering them $20,000 to sign a release. I look at their case and I think, you know what, this person could get $80,000. So if I were in their shoes, I would be rejecting the $20,000 in any case and going back and putting forward a counter offer for 60, 70, 80 grand, whatnot. So even in that case, I'm technically rejecting that offer and I'm coming in with a better offer. So there's not usually a whole lot to lose if you don't adhere to the deadline. A lot of times, even if they give you a day or a week or 3 days or 2 weeks to sign a release, if you take longer than that and you were to go back to them maybe a month later and say, you know what, I want to sign this release. I know I'm past the deadline, but I want to sign it. Odds are they're going to bite your hand off to get that signature because they know that that release has probably got a package tied to it that's way lower than what you're entitled to. So they're willing to wait, but that's not going to necessarily stop them from putting pressure on you to sign. So if you're ever in a pressure situation like that, I still say do not sign the package. I would tell the employer that I need time to review this offer. I need time to consult with a lawyer, get some legal advice, consider my options so that I can make a fully informed decision. Because otherwise, you're going to end up in a situation that I mentioned at the top of this half hour, which is a woman signing a release thinking she got, $20,000, and then I speak to her a week later and I tell her that she potentially just threw away, another $20,000-$30,000 or more had she not signed that release. So no matter how much pressure you're on, I still say don't sign it. Talk to a lawyer first, get some legal advice first, because as much as you might think you're going to lose something, odds are you're not. And in fact, by getting a lawyer involved, getting a consultation and going through it with that lawyer, you're going to probably quickly realize that your potential is way higher than the package you're being offered, and that it makes entire sense to negotiate a better offer, which can result in a huge more windfall of money going your way. I got another question in from Silver Star on YouTube, who's asking whether employers that hire look down upon applicants having a gap in their employment history. And I would say that on the face of it, if an employer looks at a resume and sees a gap, I suspect that they may have some preconceived notions about why there is that gap, but I wouldn't say that they automatically look down at the applicant for having that gap. I think it would depend on, first of all, the reasons for the gap. There are a lot of reasons that can explain why somebody has a gap in employment history. But secondly, even if there is a gap, you may still have the qualifications and experience necessary for the job. So I wouldn't say necessarily that they look down upon them. I think it's more so often just a question they would ask during the interview process as to, during the hiring process as to why there is a gap. And then hopefully you can explain it. But frankly, a lot of people have gaps in their employment history. It takes a while, depending on who you are, sometimes to find a job that's similar to a job that you may have lost. So hopefully they don't look at it and just judge face value, but it's something that can be explored during the hiring process. But ultimately, it's going to be up to them who they want to hire. And if they choose not to hire someone having that gap, then I guess that's their prerogative. And I would keep pursuing other opportunities if I were in that situation. I've just got a follow-up question from L, who was talking about being given notice of changes to the commission structure. And L's asking, what if I pursue a constructive dismissal and I lose? Can they let me go without a severance package? It is technically possible that someone could try and go forward with a constructive dismissal, which is essentially when a big change has been made without your consent. And it could end up being the case that a judge finds there isn't that big of a change that's happened. Or maybe the judge finds that you were given enough notice ahead of time that the change was happening. And in that case, or in that sort of hypothetical, a judge could say that he or she doesn't think there is a constructive dismissal, and the employer may, in that case, only have to give you the notice that they've given. So as long as they actually complied with what they said and gave you that full amount of notice before making the change, then it is possible that you wouldn't be entitled to anything further. I would still suggest you contact a lawyer and get some advice before going down the lawsuit path, and just assess really the viability of bringing forward a dismissal, a lawsuit, a legal action, because you definitely don't want to go through all those hoops and go through the court system only to find out that the odds of you winning are going to be very low, and now all of a sudden you're stuck with a legal bill. So that's why I think it just all starts at the initial consultation with the lawyer. And then from there, the lawyer can guide you as to the best way to go about it, whether it's to try to resolve things more amicably and maybe have some negotiations, or if the employer is being particularly unreasonable and there's a lot more to be had or gained on your end, and therefore it would make sense to proceed with a lawsuit. But first, I would start with the consultation. I've got another question in from Ash MK on YouTube, who's saying that their employer is laying off a number of shifts, saying they don't have enough work. How long are they allowed to keep us on a layoff? And what happens if it goes on too long? So if Ash, what you're referring to is a temporary layoff, in general, actually employers don't have the right to place you on a temporary layoff. Even if they say they're going to call you back to work, oftentimes they say within maybe 3 months, but sometimes even within 4, 5, 6, 7 months. The fact that an employer puts you on a temporary layoff without your consent, which is an important part, that actually can easily constitute a termination at law. And there's this misconception out there, frankly, from both employers and employees, that employers can place employees on a temporary layoff so long as it's due to not having enough work and so long as it's only for a certain period of time. But as I say, if I'm being told that effective today, August the 12th, I'm being put on a layoff for an undetermined amount of time, I can treat that as a termination at law and go after the employer for my severance. The only way that I couldn't do that or I can't do that is if I'm placed on a layoff, is if either I've agreed to the layoff, so I've consented, I've said, okay, that's fine, you can put me on a layoff, please call me back when you can. Then in that case, I've consented, and the employer would have the ability to at least lay me off for anywhere from between 3 and 6 or 7 months. But if I didn't say that, if I didn't agree to it, I didn't consent to it, I didn't sign any contract. Maybe when I started, they had me sign a contract, but there's nothing in that contract about being put on a layoff. If none of that is at play, then the employer doesn't have that standalone right to place me on a temporary layoff. If I have consented or I've signed something that says they can put me on the layoff, that might be a different scenario, and you may be in a situation where you do have to wait, whether it's a few months or potentially even longer. But otherwise, if that's not something you're agreeable to and you would rather just cut ties with the employer and say that there's been, again, a constructive dismissal, which is a significant change to the terms of your employment. And I don't know of any bigger change to someone's employment than being told, we're not going to pay you anymore, you're going to be off work for X number of months. I mean, that's normally a big change to most people. So that would technically be considered a constructive dismissal. And you could use the day that you were placed on your layoff as your termination date. Now, I would still recommend you get in touch with us first before you have any major communications with the company. Before communicating to them, for instance, that you consider this to be a termination, that you want severance, etc. Definitely give us a shout. But there is that ability for a lot of people out there who have been placed on these temporary layoffs to just say, you know what, that's not acceptable, I want my severance. And at that point, the employer is going to have to make a decision. They're going to have to either pay you your fair severance, just as if you had been let go in normal course, or potentially they may try calling you back to work sooner than they wanted, assuming that they allow you to come back to the same job, same pay, same everything. Then maybe that's another solution to the situation. Sometimes, unfortunately, it takes me having to get involved or a lawyer before they, come to their senses and either give you a fair package or just give you your job back, so that you're not waiting several months just thinking, well, am I going to get called back? Are they going to let me go at the end? Am I going to wait 3, 4, 5, 6 months? And then they're just going to come to me and say, you know what, we tried calling you back, we couldn't, so we're going to have to let you go. So you kind of want to avoid that situation. And in these cases, it makes a lot of sense to take initiative in some way or another sooner rather than later. And Ash, you're just following up with your question with respect to them asking you to sign something so they can keep you on medical benefits. Yeah, that could be a roundabout way of them getting you to basically consent to the layoff. Sometimes they disguise it in other language and they say something like, here, sign this thing. It'll say that you agree to the layoff, that we'll be giving you your benefits for at least, the next several months, and just sign off on it. Depending on what they're asking you to sign, I would be very careful and cautious about that because, like I say, there could be some language. Maybe it's explicit, maybe it's just implied, but you don't want to be signing something that later on could be interpreted as you sort of agreeing or condoning to this arrangement. And I think if you say, yeah, I'll sign something as long as I get these benefits in one way or another, that could definitely be seen as you agreeing to the layoff in exchange for getting the benefits. So there's sort of consideration going both ways. And now all of a sudden the company has something they can work with that they could use to their leverage and push back against any kind of a constructive dismissal claim or wrongful termination claim as a result of the layoff. So don't sign it before first talking with us, giving us a copy. We can let you know whether it's good to sign, not good to sign, and go from there. I'll answer one more question just from Malcolm on Facebook, who's saying, what if your company is bought out by a new company? Can the new employer change your wage? And generally speaking, they can't. Of course, anything's possible depending on if the new employer has you sign a contract that potentially could allow them to change your wage. So a lot of times you get bought out by a new company and then the new company says, hey, we want to keep you on board with our organization. We don't want to let you go. You're just going to continue working for us now. But, oh, by the way, we want you to sign this particular contract just to get everything formalized with the new company. And then somewhere in that contract, there's some language about, oh, we can make changes to your employment, or, oh, the salary's lower. If I'm making, say, $50,000 a year at a company and they get bought out by another company, and all of a sudden the people who bought out the company are saying I can keep working for them, but I'm only going to make $30,000 a year, I don't have to accept that, because even though I may want to keep working, I'm not going from the old company making 50 to the new company now making 30. I could have the right in that case to say, no, I'm not agreeable to this change. I'm not agreeable to working for the new company if I'm going to get paid, a fraction of what I was making at the old. And at that point, unless the new company gives you a matching wage, you may actually be able to collect full severance from the old company that was bought out. So there are a number of different options when it comes to businesses being bought and sold. And if you're an employee who's kind of caught up in the middle of it and you're wondering, should I go and start working for this new company? It's going to come down to what they expect of you, what the terms are. So before signing anything with the new company, especially, again, you want to give us a call so that we can kind of go through any employment agreement or any document that the new company is wanting you to sign, so that you're not stuck in a situation where you've signed something that allows them to change your wage, and now you're technically an employee with the new company, and the old company has no further liability. And now you're kind of stuck with that new employer, and you may be unable to get out of that wage change. So definitely something to chat with us about. But I think that's all the questions I had for today. So definitely get your questions in. If I didn't answer any, we've got these sessions going on all the time. The most recent, the next session actually is going to be a disability law Q&A with Martin. You see down below there tomorrow at 10 a.m. Pacific time. So anyone who's got disability, LTD, STD related questions, definitely tune in tomorrow. And after Martin's done, there's going to be another session for employment law stuff. So, stay tuned for that. But thank you otherwise for joining me today. Appreciate all your questions. I'll definitely be back. But until then, do take care. All the best. Bye for now.